Hey, if you've been out there waiting for some legal advice, you might know the first hour we talked with Armstrong Williams about his new book, Restoring Virtues. So if you get a chance, stop by my Facebook page, and I can link you right through to his rightside.com website, or find a link to the book. You should buy it. It's really actually a very good read. But now I'm going to start taking your legal questions for the next hour, 540-0580, 540-0580. So if you have a legal question, you've been dying to call for the last hour, we're ready for you now. Mike, you're on the air.
How you doing, Carl?
Good.
I have a question. I was down in Ocean City, Maryland, the last couple of days, and I got a call 8 o'clock in the morning.
Did you take a picture of it?
No.
Because you might need it to remember what it looks like pretty soon.
Yeah, I'll say. Well, we got out before it hit, thank God. But the parking lot for the hotel, it's not parallel parking, but it's, fender to fender down the middle. And I got this call at 8 o'clock that I had to come down right away. The guy said I hit his car. So I went down, and the guy had a 99 Mustang. And I didn't hit the guy's car. I mean, so I told him, I said, well, I didn't hit your car. He had like a license plate, and a plastic license plate had about a 3-inch crack in the thing. And he's telling me that, I messed up his bumper and his whole front end and all that. It was a nice 99 Mustang, like I said. I got a Honda. To make a long story short, I said I didn't do that. And my girlfriend was with me. We weren't even there that night before till about 10 o'clock. So somebody could have hit the guy's car, backed out, and, I took his spot, and then he's blaming me.
Right.
So I wouldn't give him my insurance stuff, so he called the cops. I said, well, call the police. So the police came, and, they wrote up an incident report, took the information, gave me a sheet. And the cop said, well, the way your license plate lines up in the front and where the mark is on there, it appears you did. But he said, let the insurance companies fight. And forgot I didn't do it. That's what it was. So I thought, I don't need this on my insurance,
Yeah, and I guess the answer is anybody can make a claim against you, right? I mean, I could just say that I was driving down the road and something blew off your car and hit me, and I saw your license plate number, and then your insurance company's going to...
There was no paint on either bumper. I mean, if I hit this guy's thing that hard, it would have been paint on both of them. This plastic thing would have been shattered. Mine would have been broken. There's no way. I didn't even hit the guy's car, but he started using the F word and called me every name in the book and all that, and I just walked away from him.
Yeah.
I told the cop, I'm not dealing with that punk, So I went down to my insurance company, Erie, and said, I told him the story, and I said, for one thing, the guy was over. I told the cop, too. I said, I'd like on this incident report. He was over the line. They have the painted line. He was over about a foot. I mean, that's beside the point. So it didn't hit the guy's car anyhow.
Right.
But I said, that's a contributing factor. If somebody hit his car and he was over the line there, I mean, not that that's the reason you should be able to do that, hit somebody. But I said, I'm in my 60s. If I nailed a guy's car, I would go in and say I hit this guy's car.
Right. You're at that point in your life where you just don't care. You're just going to, I did it.
Right.
All right.
So I did go to my insurance company and gave them that, and I told them I have the cop said, you can't use a witness in your car, especially if it's your girlfriend. My question, and he already put a claim in. He went the next day.
Right.
You could tell this car was like his baby. He was in his mid-20s. You could tell, this car like a human being to him. So I went down there and and disputed everything. And they said, we already got a call on it. Then when I got home later, I already had a call from it.
It's like any other legal problem. It's just going to be determined what's more likely than not. And so what happens is your insurance company will take a position on it. They may simply pay the claim because they feel that's cheaper and easier, depending on how much he's asking for. Or they may deny the claim, and then he would have to sue you.
Well, that was my question. I said to them, can this guy sue me if he doesn't get a claim? I think he must have done some damage some other place,
Right.
And,
yeah, he has to sue you, but then your insurance company indemnifies you, and they pay for your attorney to defend you.
Oh, do they really? I
Yes.
mean, really, it was his word against mine. I mean,
listen. Remember this. Everything's everybody's word against somebody else. It's all legal problems are, essentially.
That's true,
If there's two people whose cars contact each other front on, let's say, one of you is going to claim the other's at fault, and the other one's going to claim the other one's at fault. And if we don't have any extrinsic evidence to help us decide, like a videotape, for instance, then we just go on your word. And who's more credible? But the answer there is Like you say, he was over the line, so maybe they're going to say, you know what, maybe he did hit you, but you were contributorily responsible, so you can only have 40% of your claim. But the point is, don't fret it too much. Your insurance company's going to do what they want to do with it. If they don't pay the claim, he's going to have to sue you, and the insurance company will defend you.
Well, I'd rather have the insurance company pay than me pay,
So that's your answer, Mike.
Okay. Well, thanks, all.
All right, brother. Just don't sweat it. No big deal.
Okay, thanks.
That guy probably just angry that his car got bumped and didn't know who did it. And I was with someone one time when they sent the MPs out to pull him off a golf course because one of the MPs was claiming the guy had scratched his car, and of course he was pretty sure he hadn't. But that led to some fun. 540-0580. Bill, you're on the air.
Hello.
Hey, Bill.
Yeah, hi, counselor. My daughter was driving a car she had recently bought in May. She financed it through a lien holder. And as she was driving through the neighboring town, a 21-year-old driver ran a stop sign, and hit her broadside. And she bought the car for $15,500. And this happened on a Friday. I believe it was July 15th. And within 5 business days, the following Friday, the driver's insurance company, he's on with his parents, we had a check in our mailbox for $10,000 to fix the repairs. However, I didn't want to sign off on it. Obviously, my daughter was she went to the hospital at the scene of the accident. My wife drove over to meet her and took her to the hospital. She ended up with a concussion. She was okay, but the following Monday, she needed transportation, so the driver's insurance company authorized 23 days of rental car reimbursement.
Okay.
The car was immediately towed to a storage lot in Lancaster County. And the following Friday, the same day we received the check from the driver's insurance company, the claims adjuster for the insurance company called me during the day and asked me if I had authorized the car to be towed from the storage lot over to a local car dealer, to have it fixed. It was only a 2-year-old used car with 20,000 miles on it. Obviously, I didn't want to sign off on it because, I was in the car business for a long time, and I know about the future market value, and these days with CarMax and everything. So, make a long story short, the whole scenario has morphed into a nightmare. The day that the claims adjuster called me, and when I notified him that I wanted to have an attorney look at it, he went the other way on me. He became confrontational, adversarial, and notified me that if that's the case, we're not going to reimburse you for the rental car reimbursement anymore, and you're responsible for storage fees starting effective today. So anyway, to make a long story short, I had a local attorney looking at everything, and he told me, "Don't worry about it. We're going to get the insurance company to pay off the loan, and we're going to get plus on top of that because of the market value." But there's been nothing going on. Basically, I've been emailing and leaving messages and everything, and there's been nothing happened. About 2 weeks ago, we received a certified mail from Pennsylvania Department of Transportation. The storage lot turned in a notice of abandonment on the vehicle.
Right.
Now automatically we get a phone call from the lien holder, customer accounts department, because they have an interest in the deal. And I pointed out to them, I explained to them everything I'm explaining to you, and I also pointed out that my daughter has continued to make payments on the vehicle.
So Bill, I need a question here.
Well, the question is, the lien holder notified us that even though we've been making timely payments, even though we haven't been able to drive it, if we don't get the car out of storage on or before this coming Monday, after tomorrow, the lien holder's got to go get the car, and it's going to go down as an involuntary repossession.
Right.
And it just doesn't seem fair, seeing as how my daughter was the victim here. she ended up with the concussion, and now even though she's been making the payments,
but the car's not been retrieved from where it's at, right? I mean, in other words, it's in some.
The storage lot won't release it. They want $1,700.
They want their storage bill.
Yeah, they want $1,700.
Yeah, and the problem is that you got three different things going on here. You got a potential lawsuit. You've got a car that's being stored by some third party who doesn't care about the outcome of that potential lawsuit or whether you settle with the insurance company or not.
Right.
And we have to figure out how your car got there. But the long and short of it is, until somebody pays that bill, they're probably not going to release it. And worse, they're going to use the salvage law. Then they're going to then the lender's going to go pick it up and call it an involuntary.
Correct.
Because they have to.
You.
And here's your problem. Your problem is the storage lot doesn't have any stake in what happens between you and this insurance company. So you got to either get your legal team to sort this out right away and get everybody on board, or somebody's gonna have to plunk out the money and then worry about recollecting it later.
Right. Well, I'm on a fixed income. My wife lost her job two months ago.
I understand, and that unfortunately in the legal business we can't make money come out of the air to solve a problem. The only thing we can do is try to get everybody on board.
I made the suggestion when the lien holder called me. I said, look, this was last Monday. I said, look, why don't you get somebody from your legal department to call my attorney and let's sort this thing out. There's mitigating circumstances here. They said they would on Monday, but there's been no call made. Everything's the deal's growing mustache.
Well, Bill, long and short of it is, I guess the best I can tell you is somebody's got to pay the money and then sort it out later, or somebody's got to agree not to get paid now and maybe get paid later, but then they're not 100% sure they're going to get paid. All right, dude, I got to go to break. Hey, welcome back. Carl Rominger here answering your legal questions, 540-0580. First-time caller, don't know anything about what's going on here. Well, we are a law firm. Actually, I'm a principal lawyer of Rominger & Associates. We've got 6 attorneys. We cover the mid-state, so if you can hear the signal, we can help you. But we come on the air 1 o'clock to 3 p.m. every Saturday and answer your legal questions. And, of course, occasionally we talk about current political topics and things. That's why we had Armstrong Williams on earlier. Steve, you're on the air with Carl Rominger.
Hey, Carl. How are you doing today?
Good.
Good. Appreciate your help. Enjoy your show. I'll keep this short and simple. I wanted to discuss executor fees.
Okay.
Is there a standard set fee or a maximum fee that an executor can charge in the state?
There is no legal limit on an executor's fee, if that's the easiest answer, and there's no minimum. Generally speaking, courts are going to look to see that it's fair and that it's proportional. And so, kind of interestingly, if you have a very large estate, the fee can't just rise to infinity. Conversely, with a small estate, the fee might actually eat up a very high percentage of it because the work is still the same for the executor.
Gotcha.
So it's kind of funny because, you say, well, maybe let's just pull a number out of the hat and say 5%, right?
Yep.
On a $100,000 estate, that'd be $5,000.
Yep.
It might adequately compensate a person. It might not. For the amount of work they do. But on a $2,000 estate or a $5,000 estate, 5% is never going to cut the mustard.
Right.
On the other hand, on a $10 million estate, 5% is probably a gross overpayment. And so now there is a case out there, and it's an old case that refers to some attorney's fees and executor's fees, and they were supposedly approved by the Attorney General of Pennsylvania at one time. And I forget the name of it, but the idea is a lot of lawyers think that's a safe harbor. In other words, if you use those numbers. But basically, you're always stuck to, you always potentially could be challenged by any of the heirs as the executor as to the reasonableness of your fee.
Okay. So as an heir, I might have the ability to challenge what I think might be an excessive fee.
Correct. And of course, the answer is courts are going to look at a lot of different factors when they try to figure that out. But I guess the simple answer is, if an executor or executrix is doing their job, it is a lot of time, and quite often it's a lot of time during a point in their life because usually there's somebody who is close to the decedent where they're under a lot of other stresses. And so I'm not one to say that courts are going to frequently second-guess a fee, but they're certainly going to also look at, for instance, if you're the only heir to the estate, well, obviously who cares what your fee is, right?
Right.
On the other hand, if you're, if it's 3 brothers and sisters, a lot of times somebody will just forego a fee.
Yeah.
And if everybody's on, and actually, an executor's fee is a taxable income, whereas money from the estate might not be taxable income.
Right.
So there might be an incentive to waive your executor's fee in some circumstances just from the tax swing.
Sure.
But that's going to vary as well. I guess that's a very imprecise answer, but I think you understand what I'm saying is it's pretty much a reasonableness. And I'll give you an example. If the executor comes in and says, listen, I'm literally the person who got down on my hands and knees and scrubbed the floor of the house before it was sold and cleaned the place out, and here's all the places I ran to, and here's all the work I did and all the meetings I went to, they're going to have a much different position in front of a judge second-guessing it versus somebody who literally just got sworn in and found one large cash account, which was the only thing in the estate, paid a few bills, and then says, I want 17% of it.
Yep.
All right.
You've answered my question.
Thank you, brother.
Thanks, Carl.
540-0580. Dan, you're on the air.
Hey, Carl, it's Accident Saturday, so I want to contribute, and I want to ask a question. I'm going to try and keep this short. My wife was rear-ended, hit so hard the seat broke.
Ooh.
When the car was in for repairs, it's in 3 or 4 times. I finally get it back. Don't get any paperwork from the repair shop. They were supposed to do an alignment, and when I questioned the insurance company, they sent paperwork to the insurance company that said they did do it. I asked for a printout from the machine, from the alignment. They finally sent one to the insurance company. Here, it failed the alignment. They sent it back out, said, hey, it's all repaired. I took it someplace else. They said, this vehicle cannot be brought back into alignment without more parts. So I'm thinking I've got an insurance fraud. This was not just a mistake because, like I said, I had it in there 4 times for repairs. It's been a bone of contention with them. Now, let's just assume that you're going to get this case. Would you rather the person file a report of insurance fraud with the insurance commissioner first, or wait till after and just name them in the lawsuit that may be pending?
Yeah, the short answer is the less overlays, the better. So that would be my thought on the matter. The less overlays, the better.
I don't understand what you mean by that. So
I just mean that the more parties and things there are in motion, the more complicated things could be. And I don't think there's probably you have plenty of time to report somebody for insurance fraud. The other question is it really fraud, or was it just bad?
Well, I can tell you they had the vehicle in 4 times. They did everything they possibly could to make sure they got this out as cheap as possible and not bring it back into the original condition, including putting rusty old parts on, and that even the insurance company said, no, they should have never done that. Right. And this one is clearly, when I asked for the paperwork, there was no paperwork for the alignment. When I started shouting and yelling about it, the insurance company finally got a supplement that said that they did do an alignment, but they weren't forthcoming with the printout. When I demanded the printout, that's when we found out that, there was an alignment done. All the paperwork is there, and it could not be brought into alignment. That's when they sent it out saying it was okay. So to me, that's fraud. If I perpetrated a small fraud against an insurance company, the old 27-inch for the 47-inch TV, the insurance commissioner would be all over me. They'd call that insurance fraud. But when a business does that to an individual, I don't know if they're going to look at that and say, it's a reasonable mistake. With all the other data that I have and everything they've tried to pull from this point forward, it may look like insurance fraud, but, it's one of those things. Can you prove it or not? And that's why I'm wondering if it'd be better to make them understand and make them pay to name them in a forthcoming lawsuit. Because, like I said, my wife was hit so hard that the seat broke, so she's still got some pain.
Yeah. Now, of course, the person you really sue is the person who hit her, right? We lost him. All right, Dan. Well, if you're still listening, I mean, the short answer is you can certainly drag third parties. But if I had a personal injury lawsuit, I don't really want to drag somebody who didn't do a good repair job on the car back into the same lawsuit. I'd name them in a separate breach of contract lawsuit for not repairing my car like they were supposed to. I don't think I would drag them into the primary personal injury lawsuit, if in fact there is one. It's 540-0580, 540-0580. That's our talk line number. If you want to get on the air here and ask a legal question, if you want to know more about what's going on with the hurricane, don't ask me because I'm not sure yet, except that it's going to work its way up the coast, and be prepared for some bad weather. I know that. And while we're talking about auto accidents, I just want to remind anybody out there who has car insurance, go check your car insurance. Get your declaration sheet out. or get your policy out and make sure a couple things. Make sure you're full tort, not limited tort. If you have limited tort insurance, get rid of it. If you think that limited tort insurance is a great idea and I'm full of phooey, call in and I'll explain it to you here on the air. Also make sure you have uninsured, underinsured, and that you have the same policy limit on that as you do on your primary insurance. So, for instance, if you're carrying $100,000, $300,000, I think your uninsured, underinsured should be the same. And if you're independently wealthy or otherwise have a lot of assets, make sure your policy coverage is high enough to protect those assets. That's particularly important if you're a single individual. 540-0580. Cindy, you're on the air.
Hello?
Yes, Cindy.
Oh, hi. I didn't hear you say Cindy. Anyway,
That's okay.
I have a question about car repairs to follow up on that gentleman in a way. In April, I was in a car accident, and my left driver's car door was buckled in, and I took it to a repair collision shop up in Mechanicsburg, and they kept it for 2 weeks and gave it back and said it worked fine. Well, it didn't. It didn't. When I picked it up, the door itself didn't shut, and I could hear air coming in through the door. Mm-hmm. So they took it back. They fixed it again, they said, and this time they kept it for another week and gave it back. And I still have the same problem, except this time I went to wash my car the other night, and now there's water coming into the door and the window, and it's going down into my speakers and the mechanisms in the car, and they're telling me that it's the best that they could do.
Interesting.
I have Nationwide, and I you pay premiums all these years, and I don't mind paying, but damn it, when it comes to getting my car fixed, I expect it, like the other gentleman said.
Yeah.
You just expect it to be done right. Don't think that because I'm a woman, you can just say to me, hey, this is how it's supposed to be, or the car has over 100,000 miles. My car looks totally brand new.
Right.
And I just refuse to accept that excuse. So when a company says to you, well, it's the best that we can do,
and that's the insurance company saying that, or that's the repair guy saying that?
It's McCafferty Ford saying that.
Oh, I want to know the actual name of the company. I just want to know and because I don't know what they've done or not done. And so, like Bob Durgan says, we don't know the full story, and we don't know if it really is their best or not their best. But here's the answer. You usually would want to take the car to a third party, somebody who does the same type of work, and have them tell you, like, this is the best that can be done under the circumstance, or they forgot to put a gasket in, and let me show you where the gasket should have been. Because if the water's getting through, it sounds to me like one of the rubber gaskets in the door is damaged, or the door's warped in a way that the gaskets aren't never going to line up, and therefore you would probably need a new panel, and somebody's trying to avoid paying for that. So I would take it to another body shop and say, here's my problem. What's wrong with this thing? And it might cost you some money on the front end, and then ultimately you're going to recoup that either from your insurance company or the tortfeasor.
Okay, I generally apologize. I normally don't say the name of the person or company.
That's okay. I'm just telling you that I have to always kind of caveat it. Like, I don't know what's going on here, but you take it to a third party and get a second opinion. And unfortunately, but you'd have to do the same in court. If I go and see the judge and say, hey, judge, I'm a lawyer and I got an opinion on this, he's gonna look at me and go, Rominger, I don't think you know anything about cars. Get me somebody in here who knows something about cars, because the defendant who does know about cars says it's the best it can be. So you got anybody who says different, I'll listen to them. Okay. So you kind of got to get the independent opinion on the front end.
Okay. Would it have to be another collision center? Could it be the gentleman who works on my car?
It could probably be anybody who knows enough that he could convince a judge that he's telling him the truth and he knows what he's talking about. Okay,
because they did replace the gaskets twice now, and I think they just don't want to have to replace the whole door panel.
And I think that's I'm not an auto expert, but my gut is that something's warped in the door, so the gaskets are never going to line up right, so you're not going to get a good seal. That's my gut.
Okay.
But this isn't car talk.
Okay, I was considering writing them a letter and giving them one more chance, though, to fix it.
Yeah, you could try that too. But then again, then your car might be gone for another week.
Okay.
All right, Cindy, good luck.
Thank you, Carl. Bye.
All right, bye. Tony, Mark, I'll take you after the break. 540-0580. Hey, welcome back. 540-0580. First bands of the hurricane are over us now. I can see from the satellite. Obviously, we have better access to weather here at WHP 580 than the average consumer. Tony.
Yes. I have a question.
Yeah.
Okay, you said something about full tort versus limited tort or partial tort, something like that.
Yes.
I just moved up from Maryland, and this is like whole new territory with this insurance stuff up here.
Yeah, welcome to Pennsylvania. In Pennsylvania, our legislature created a regime brought wholly by the lobby of the insurance companies to help screw the average Pennsylvanian out of full coverage. Now, theoretically, it saves you some cost, but what it later means is you can't sue for pain and suffering unless you have a serious bodily injury that impairs you in your life's function. So theoretically, someday you could lose. Right now, if you lose a leg, they'll count that as serious bodily injury that impairs life function. But if the prosthesis were good enough, the insurance company could argue under the law that you haven't lost any use. And so we have cases where people have been terribly and grievously injured and laid up in a hospital bed for 8 months. But because they make a good recovery and they can still ride a horse, which is the only fun activity they ever did beforehand, for instance, and they can still go to work, our courts will say you can't get pain and suffering. You're only entitled to your medical bills and your lost wages. And what ends up happening is a lot of times there isn't a lot of hospital bills or there isn't a lot of lost wages for whatever reason, and then they essentially get no recovery, even though they've been grievously hurt. So you have to be very careful when you sign up for insurance here in Pennsylvania that you get the full tort policy. You have to sign a form to ask for limited tort, and a lot of people are talked into it because the insurance adjuster wraps their arm around. He says, listen, if you're ever hurt seriously, you can still sue, okay? But they don't explain it the way a lawyer would, which is not only do you have to be hurt seriously, but you have to have a permanent impairment. And by the way, our courts have been very harsh on the definition, saying the legislature means what it says. And so we don't measure how much pain and suffering you had or how many days of work you missed. We measure it only whether it's permanent or not.
Okay.
Makes sense?
Okay.
So make sure your insurance policy is what we call full tort. Number two, you want to make sure you have good coverage for uninsured, underinsured, which is the stuff that pays you when someone else hits you. If 1 in 5 drivers is not insured, and if one of them hits you and you don't have uninsured, underinsured coverage, then you'll never get any money to make up for your lost wages, your pain, your suffering, or your medical bills. And also make sure you carry good first-party medical coverage. The state minimum is $5,000 on that. Everybody should carry a minimum of $100,000 on that.
Okay.
All right?
Yeah, I think the way I have it set up now is we have $500,000, and then the medical end is $100,000.
Perfect. Just make sure it's full tort.
Okay, now what's the difference, this whole stack thing? I don't understand that.
Stacking means that if I have 3 vehicles and I'm stacked, I can stack my uninsured, underinsured motorist coverage on each. So if I have 3 at $500,000, I actually have $1.5 million in coverage stacked. If I waive stacking, I still only have $500,000 in coverage. And people will be like, well, I don't need that much coverage. I don't need to stack it for an extra $13 a year or whatever. The answer is you should stack it because catastrophic injuries occur more often than you can imagine. And in the modern world where the healthcare is so good, when they load you on that helicopter and fly you 47 miles to the hospital, you get a $28,000 bill for the helicopter ride. Then the trauma center puts you back together, and they have a $72,000 bill. And then you're in rehab for 8 months. You can start to see how $1 million in coverage actually could be implicated in just a run-of-the-mill auto accident.
Okay.
All
now,
right.
that's a stacking thing. Is that just for the underinsured?
Yes.
Okay.
All right, my friend.
All right, cool. Thank you.
All right. Yeah, welcome to Pennsylvania. We got a whole different regime up here on the insurance. 540-0580. Carl Rominger here answering your legal questions. Make sure you go to weekendappointment.com and claim your free will. Just fill that kit in, fill that kit out, send it in, and I will sit down with you and go over your estate planning needs, and we'll figure it all out. Lots of you have done that. I know a lot more you haven't. If you've got a spouse who's been slow about getting a will, or you just have one that's 5 years old and you want to make sure it's up to date, we'll take care of it. So go to weekendappointment.com. And, of course, check out romingerlaw.com as well for more information about our firm, the areas we serve, and what's going on. We always put some informative articles up there. The lawyers in the office write. Mark.
Hey, Carl. How are you?
Good. What's going on?
Well, let's try something a little lighter.
Okay, yeah.
Okay, a woman and I live together. We have a 7-year-old daughter.
Okay.
House is in both of our names. Mortgage is in both of our names. We also have 2 spaces downstairs that we rent, one to our own, or my corporation for her hair salon, and a beauty salon on the other side.
Okay.
Now she's asking me to leave. I had another house when I was single, sold it, put most of the proceeds into down payment on this house. This was never going to happen to me, so what do I do?
I'm chuckling. The short answer is there's no great answer, okay?
Yeah, I figured that much.
If you're unmarried, sorting the property out is sort of like a partnership / contract law endeavor. I've actually thought that the legislature should create a special set of laws for unmarried individuals, recognizing that many people cohabitate, but it will never pass because there's a certain segment of society that would believe that that's anti-marriage and anti-family.
Yeah,
so
of course.
There's just no way to get that passed, although it would solve the practical problems here and make it much simpler.
Why do you want to bring that up?
Right. and frankly, the only advantage is, because you're outside the marital law, you can avoid spousal support and things like that. So, that's an upside to this whole endeavor. But basically what we would do is kind of just do we'll declare it a partnership, right, or a contract, and we'll figure out who put what into it, and then we figure out who's owed what out of it. And then the only messy part is all the factual breakdowns. She's going to remember that she put in $2 billion, and you're going to remember that you put in the $2 billion.
Right.
And then we'll have to sort that portion out. Now, if you guys can sit down like adults and figure it out, you'll be rare.
Yeah.
And particularly because these questions come up when the relationship is usually not in its greatest shape or form, is the other complicating factor. So I guess what you'd want to do is sit down maybe with someone like me, and we'll put together a proposal and, hope that the other side comes to a similar figure. And if you can find a happy medium, figure out a way to dissolve everything. If not, then you have to litigate. And then it gets to be factual. So, for instance, if you paid money in on the down payment, we should have a check somewhere, right?
Exactly.
So we have some proof there. If you've just been giving her $700 a month in cash towards the bills, then the factual question is going to be, will she admit that or not? And do you have any other proof of that?
Right. Well, luckily, I've been taking care of paying most things. We both have, or I have direct deposit for my funds from my job, and she, like I said, we work for ourselves and rent to ourselves.
Right.
Now, the problem with that corporation is we've always filed jointly or separately, filed single, and we've listed her as vice president, even though she never put anything into the corporation actually.
Yeah, except she may actually be at this point partly. Well, of course, a vice president's not necessarily an owner of a company either.
Right.
In fact, to quote my corporations professor, a vice president is an empty basket.
Yeah.
Because they don't really, the title doesn't mean anything, and there's a vice president of everything in some big companies.
Okay. Well, so the rent that we get from those two things, we've been splitting down the middle.
Mm-hmm. Well, which would tend to show a plan there. So yeah, she may be partial. You guys might need to buy each other out of each other's respective corporations, but maybe that's easy.
Yeah. Okay. She doesn't really have. She's, as far as I'm concerned, an employee.
Right.
But
well,
that gets thicker and thicker. Right?
Yeah. You backed yourself into one of these positions that probably half of America's in right now.
Oh, I feel better now.
All right, Mark. I guess that's the short answer. Is we treat it like we try to figure out what how to define the relationships, and we define them as business, contract, and partnerships, and then we apply the partnership and contract law to that and try to back out of the things. To the extent that we can't adequately address it with law, then we can always claim unjust enrichment. But any which way we do this, it's not going to be pleasant, and it's probably going to end up costing you something.
Okay. And could you give me your office number again?
Yeah, it's 241-6070 is the office number, 241-6070.
And that's 717?
Yeah, it is.
Okay, thanks, sir.
All right, brother.
All right, bye.
540-0580 is the talk line number, 540-0580. I'm going to go to break. Oh, yes, I can't drive 55, and Shane knows, and I say that all the time because, well, let's just say, oh boy, I'm just thinking about a car with like a 12-cylinder engine in it, that feeling of acceleration you get. Carolyn, you're on WHP 580 with Carl Rominger. What's going on?
Well, thanks for taking my call, Carl. I have a question about propane tank ownership.
Okay.
This is a buried tank, 500-gallon, that was buried on our property. The property went through foreclosure when we purchased it, and our sales agreement with the bank said that we bought everything on and in, and on the property.
Right.
I called when we moved in. I called a propane company. They came out. They told us if we signed up for a service agreement, they would give us and paid for so much propane in advance that we would get a discount. So we did that. They had to sign a sales or a service agreement for an above-ground tank, and we did that. And they copied down all of the numbers off of our tank and regulator. And here, having never rented propane tank or never having used propane, we found out that they were charging us a huge difference between the going rate for propane and what they would charge customers. There was like a $3 or $4 a gallon, $2 or $3 a gallon difference. I said, "Well, you don't own our tank." And they said, "Well, yes, we do." And I said, "Well, prove it." And they sent us a copy of this sales agreement, not a sales agreement, a service agreement. And I said, "But that's not proof. This is the numbers that you copied off."
Right.
And so they said, "Fine." I said, I sent them copies of our sales agreement with the real estate through the bank. I went and I did title search on our own through the courthouse. There's no liens, no nothing signifying that the tank belongs to any propane tank company. They turned us over. They started charging us lease, and they kept compounding. All while we were disputing this, they kept charging us this yearly lease, and then throwing on a $40 late payment fee until now it's up over $277.
So how much? So they're saying that you owe because they're saying that you owe a lease fee on this tank.
Yeah, now they're saying that we own a lease fee on the tank, and we're refusing to pay it because in my opinion, as soon as I pay this money, that signals that yes, we concur that we have the right to pay it.
Thank you, Carolyn, first of all, for doing what nobody else seems to do, which is recognizing that paying a disputed debt is often an admission that it must be owed. And I get so mad because people call me up and they say, well, I don't really owe this guy money, but I've been sending him $25 a week to keep him happy. And I'm like, what do you think the judge is going to say? Or what do you think the law's basic supposition is that if you've been paying it, you must think that you owe it. So that's probably a really easy way for us to solve the problem of whether you owe it or not. And in fact, the law says an acknowledgement of the debt by paying it quite often is fatal to a claim that you don't owe it. Mm-hmm. So good work there, number one. Number two, I'm not sure what the situation is, and I'd have to study it a little bit to figure this out, but it would seem to me that if it is somebody's propane tank, whoever owns it and is leasing it to you, if it belongs to somebody, then certainly they would be free to take it back, and you shouldn't have to pay for it. But if it was bought or has become part of a fixture of the property and is not owned by somebody else, then you own it, and then you shouldn't have to lease it.
I would have thought once it went, if in fact another that propane company or another propane company owned it, once it went through sheriff's sale,
yeah,
they had the right to claim it at that time. And if they did not, or even if they could, they haven't even been able to provide proof other than that one agreement that we signed that they own it. They have no paperwork.
Yeah, I'd have to see in the agreement you signed. Did you acknowledge that they owned it in that agreement?
No, I did not.
Okay.
And it's a buried tank.
Right.
It's an above ground sales and service or above ground service agreement.
So, My advice to you would be, if you want some help with this, call my office. Steve Snyder is my he was in the modular home industry for years as a lobbyist, and has kind of an expertise with buildings and construction and these types of issues. So that's who I would tell you to call, because he would probably be able to better ferret out a short answer for you than I could.
Well, they turned us over to a collections agency. The collections agency could not prove that the debt was legitimate.
Right.
So finally, I argued with their legal department, and the general manager of the gas company sent us a letter saying that although we don't believe we do believe the tank is ours, we're not going to argue with it anymore. So here we're giving the tank to you.
Yeah.
Okay. So we thought it was over with. Now they've resumed billing us and charging us $40 a month late fee.
Huh. Yeah, that doesn't sound right.
I don't know what to do anymore. Yeah.
That doesn't sound right. Well, be happy to help you straighten it out.
I'll give you guys a call.
All right. Thanks, Carolyn.
Thank you.
Yeah, maybe they just forgot they decided to help you out. Steve, you're on WHP 580.
Hello, am I on?
Yes.
Hi. Question about child custody. My girlfriend, or my brother's girlfriend, they were living in separate houses in Pennsylvania. They got together and moved out of state.
Uh-huh.
And 4 months later, she leaves in the middle of the night with the child and goes to Pennsylvania. Is she required? How would they do the child custody for that? Is that a Pennsylvania case?
Okay.
Or
how old's the kid?
6 years old.
6 years old, and they lived in Pennsylvania for never?
For his whole life, they lived in Pennsylvania.
And then they
lived in two separate homes, and he had custody of the child. He had primary custody of the child.
There's a custody order in place?
There was a custody, under court order for over a year.
Okay, if there's a court order in place, then that court order should remain in full force and effect until Pennsylvania withdraws its jurisdiction.
Okay, so even if they leave the state, that doesn't change the...
It doesn't automatically. If one parent leaves the state, Pennsylvania retains jurisdiction. If both parents leave the state, then another state could assume jurisdiction without getting Pennsylvania to drop it first.
I don't understand what that means.
What that means is right now, the way the interstate custody agreements run, the state who wants to take... In other words, if I move to Maryland and I have a Pennsylvania custody order that affects my kid, and one of the two parents is still in Pennsylvania, the Maryland court has to ask the Pennsylvania court to give up jurisdiction before they can assert jurisdiction.
Okay, but they both moved together.
Right, so they move somewhere else together, and they're both in a new state, then either one of them can ask the new state to assert jurisdiction. If one of them comes back to Pennsylvania before anything's filed, they can keep it here in Pennsylvania.
Okay. Okay. And so the father still lives in North Carolina. So can he request the child back if he still has primary custody and he's in a different state?
Yeah, I mean, he's in a different state. Where's the mom at now?
The mom is back in Pennsylvania with the child.
Yeah, he could still request, but he needs to come to Pennsylvania at this point and do that if she's back in Pennsylvania with the child.
Okay, so he's either come to Pennsylvania and then he can, demand or request?
Yes, have him go to romingerlaw.com. We have a little bit of custody information on there, and he can contact us. I got to go, guys. It's been great being with you. I'm glad I was able to answer some legal questions. I'll be back next week, and thanks for tuning in and listening to Armstrong Williams. See you next week.